Hi friends from around the world. Isn't it the first thing the client asks you for when talking about UPC litigation? How much does it cost? Are you with me? So in order to take a decision on opting out or not opting out, you want to know what is the cost of the UPC litigation and how much you have to expect to pay, and is it recoverable, and so on, and to what extent there is a possibility to recover the cost. So this is what we are talking about. So just to be clear here, I'm not talking about unitary patents so far, right? I'm talking about the situation you have a European patent and you are faced with a question to want or not to want to join the UPC litigation system. So I will talk only not about unitary patents so far, that will be for the later videos. No, I'm talking here only about what is the cost of litigation once you come to a situation where you have to litigate. So this is the first thing. But let me go perhaps a step back. We talked about the legal framework. You should understand how the legal framework is being conceived here in order to know where you are situated at each moment. So we talked about the UPC agreement, right? The Unified Patent Court Agreement, which has to be signed by the member states, etc. Now, the Unified Patent Court as such, they have rules of procedure, right? So what is, the written procedure, the interim, we will go into that in a further video, but this is about how the hearing are going on, and it is in person, not person, expenses, everything, judges, everything is in there, rules of procedure. Now, we are talking about the cost here, and the cost as such. So if you put everything in the rules of procedure, it is too burdensome in order to adopt. And the fees, they have to be adapted in a more flexible way. So it is still a different legal instrument which have been chosen, which is the UPC rules of recoverable costs, of the recovery of the costs, right? So these are the three, so to say, so far important legal instruments which we are looking at. So let's come to what are the general principle. You are happily interested probably to know whether it is recoverable or not. The general principle is, and that is not astonishing to you, the general principle is that there is a possibility to recover the costs. So to say, the general principle is the loser pays it all. It pays its own costs, and it pays the costs of the winner of the case, right? Now, this is being done in once the case is closed. In principle, then the filing of the costs have to be done with the judge-rapporteur. The one who proposes decision, etc., is also the one who decides over the cost issue, the recovery of the costs. Now, you put in your costs as the winner, claiming that the judge decide that this cost have to be borne by the other party, by the losing party, and the judge hears the other party with regard to your cost claimants, and if the other party objects, you can have another round of arguments in order to, at the end the judge will decide on the cost. An appeal is possible also on the cost issue. This is how it is done, and it can be enforced in the contracting member states as well. So this is about the adopting, so to say, the cost decision within the court. Now, what well, the general principle takes it all, but there is another general principle beside that, which says that the recoverable cost or the cost which is claimed to be recovered can only be recovered if it is reasonable and proportionate. And there is a wide discretion with regard to the judge-rapporteur in order to make its decision on that. But we will come to that. Let's now see what kind of cost do we talking about. Well, first we are talking about the court fees. Then we are talking about the attorney's fees. And finally, we have, so to say, other expenses like the witness part. So you as a claimant, you have a witness, you have to pay a certain upfront, a certain amount so that the witness can be, and the witness will be receiving its reasonable cost expenses from the court, and then you talk about the recovery of these costs, right? Now, with regard to so witness, there's witness, but there is also interpretation costs, there is other expenses and hearings, travel costs, whatever it can be. So these are the three types of cost we are talking about. Now, in order to get into these costs a little bit, there is one, so to say, common denominator for the court fees and the attorney's fees, which is the VID, the value in dispute, or in German that would be Streitwert. It is, so to say, probably based on the German practice. The Streitwert, the value in dispute, is what is about the value, what is the claimant's, the claim of the claimant, if the, so to say, the claim of the claimant is damages and he asks for, 500,000 euros to be awarded by the judge or by the judges, then the claim of the value in dispute would be 500,000 euros. That is quite clear, right? If it is an injunction, well, an injunction, it may be less clear, but for example, an injunction often is the following step of a cease and desist letter. And if it is a cease and desist letter which says, well, if cease and desist with a declaration that to be signed by the infringer, that if once again such situation or infringing situation will repeat, for each infringement situation, the person or company will have to pay, 500,000 euros. So a high amount. Though it may be, my point here is for injunction, it may be as well as high as, 250, 300, 500,000 euros easily. So the value in dispute is not 1,000, 2,000, 3,000, it is in the hundreds of thousands. The patents, the more important the patent is, the more important and the more higher is the value in dispute, right? So this is about the value in dispute. I will not go, so normally it is about the claimant. He has to pay the court fees up front, and it is the claimant who determines, so to a certain extent, what would be the value in dispute, because it depends on on the value of dispute what he has to pay. And there is also, as a side remark, the fact that the value in dispute, the higher it is, also the attorney fees are, so to say, dependent a bit on this value in dispute. So there might be, if you want, an incentive for the claimant lawyer to make a higher value in dispute claim for its own benefit. But anyway, My point here is value in dispute is an important issue and it may be quite high. Now let's come to the court fees, right? So there is a fixed fee and value-based fee. Here on the screen, what you have is the UPC rules of recoverable costs from 2017. So we do not have this legal instrument adopted yet by the Administrative Committee of the UPC. That was a draft decision on what I am basing now my presentation is a draft decision of 2017. But the logic is the same. It may be adapted for inflation purposes, but it will be around this structure, and the value will be not much different. So as you can see, we have court fees in general of 11,000, fixed fees, 11,000 euros. And you see, well, there are some other exceptions. You see here on the screen that there are other proceedings where it is less. I will not go into much into detail with regard to those ones. And then you have the value in dispute. So if the value in dispute is up to 500,000, there will be no other court fees. But if it is higher than 500,000, then you see it will go each time a fraction up. And as 50 million, it is 325,000 euros, the value-based fee plus the 11,000. So it is quite substantial as court fees. So this is an important issue. If you come from trademarks, the European Court of Justice is free, so to say. So you don't have to pay. You have to pay for it, but for this court and the Court of Appeal in Luxembourg again, the Court of Appeal of the UPC system. So this is quite substantial. How will the value in dispute be decided by the court? So I do not go much into detail here, because the practice of the court will tell us how they will react to it. And once we get a practice, well, we make another video and you will get it, right? So this is the court fees. Now let's come to the attorney fees. The attorney fees depends, well, on the difficulty of the case, of the value in dispute, of the national schemes, of what is now has been presented as recoverable attorney fees at the European Court of Justice with regard to, for example, trademarks and designs. So there are some precedents. But we have, so to say, a limit. It's an upper limit, but things we have no gravity here, so things tend to go to the upper limits, and therefore we have some caveats and some limitations with regard to attorney fees. So in one country, for example, you have a low attorney fee. In another country, you have a very high attorney fee. So there must be some arbitration here. And the arbitration is, you see here on the screen, there is the upper limit, so to say, with regard to the attorney fees and the value in dispute. But it must be reasonable and it must be proportionate to the case. So not in every case they go to the upper limit, right? That is normal. And not in a simple case you may go to the upper limit, because you will say, well, that's not reasonable. We have also here to see what will be the future practice of the court, in order to see, how, to what extent the attorney's fees are recoverable or not. Anyway, I talk about the winner and I talk about the loser, but more often than not, you don't have a clear winner and you don't have a clear loser. So there is apportionment of costs also at the discretion of the judge-rapporteur. It may be 1 quarter, 3 quarters, or it may be, what else proportion the judge-rapporteur seems pertinent. Again, you can go to appeal, but this is more often than not subject to appeal. Discretion is what it is. It's a kind of discretion. And what is reasonable, well, we will see over time how this plays out with regard to precedents in the future. And then we have the other fees. As I said, so interpretation fees or witness fees or travel expenses or the other copies and other kind of fees, office fees, which can be claimed and which, if they are proportionate and they are reasonable and they are related to this case, then they are not capped, but they are agreed upon. But these are not the main expenses. The main expenses being, well, depending on the value of the dispute, but normally the main expenses are the attorney fees. So this is the gist of what I wanted to tell you with regard to the cost. So you have an idea. Participating in the UPC system, I can incur on behalf of the client into these, and I will advise the clients accordingly. Now, let me wrap this up for you. We have talked about the 3 instruments. You will have on the downside in the text of this video, you will have the link to the legal instruments, whereas the legal instrument of the recoverable costs, UPC rules on the recovery of costs, this is not yet decided upon definitely by the corresponding administrative committee. This will be done until, well, I think October or the next meeting, because the draft exists already from 2017 and it will not change much. So this video is based on the draft. So the 3 instruments, and we have the 3 types of cost, which are the court fees, the attorney fees, and the other costs. And the important concept here of the value in dispute, which will determine part of the court fees and part of the attorney's fees, or big part of the attorney's fees. So hopefully you enjoyed this video, and we will go further now with regard to other things with the UPC system, for example.